One of the things I really love about at least the plaintiff's bar for civil personal injury work is the collegiality. What is that like on the defense side?
The plaintiff's bar, from what I've seen, they do a lot better of a job of sharing information. It's not like, hey, this is my client. I'm going to keep this motion or this practice a secret. I don't want anyone else to find it out. On the defense side, it almost seems like, hey, I came up with this great novel argument, but it's mine. I'm not going to share it with you. Well, secret's out. Once you file it in a motion, it's public record, at least in Florida. Everyone's going to find it.
This is Courtroom Stories and Tactics by RVA Trial Lawyers, hosted by Sharif Gray and Niall Abuzaki.
All right, before we get into the podcast episode, I want to take a minute or two and introduce you to a friend and colleague, Jenny Shadini. Jenny is a former prosecutor from Baltimore City, and now she works as a settlement consultant. We work with her often on helping our clients really maximize their results. Jenny, it's really great working with you and having you as a supporter of the podcast.
Thank you, Sharif. Hi, everyone. My name is Jenny Shadini, and I work as a settlement consultant, which means I work with attorneys and their clients in various settlement planning needs, such as structured settlements, whether or not to utilize a trust, how to protect government benefits, and overall providing financial security to your clients.
And Jenny, how could people get a hold of you?
The best way to reach me would be my cell, which is 301-332-1031. Again, that's 301-332-1031.
All right, we're back. And today we've got a good friend and a fellow, should I say, is prison mate? Is that the right word, Jason? So Jason Boone and I, while at different times, both went to a small school in I guess, Southern Virginia, right? No, on the western side of the state, called the Virginia Military Institute. And Jason and I connected a few years ago through LinkedIn, and we've been in touch. And he is a civil defense attorney. He's one of the few that I actually agree to talk to. And I'm joking. But Jason, no, I'm really happy to have you. Jason, you're class of 2004 from VMI. I'm class of 2011. And for those of you who aren't familiar with VMI, it really is a cult. So, and we're very proud of it, right? But, and actually now I realize it, but my diploma is like literally right behind me. So Jason, can you see and actually I see yours right behind you. So, and I see the Newmarket thing behind you as well.
Yes.
So, all right, guilty. Please, Jason, take a minute, go ahead and introduce yourself.
Thanks, Sharif. Great to be here. Like you said, I'm class of 2004 from the Virginia Military Institute. Right now, I am a civil defense attorney in Florida with Tyson and Mendez, a partner in the Jacksonville office handling cases all over Florida, and then also admitted in Georgia, where we also have another office. So I'm up in the Atlanta office as well. So great to be here. I'm looking forward to today.
Well, let me take you back to a number of years ago. Your daughter, if I remember the story correctly, was about 8 months old. You were out of town at a trial. Tell us about what was going on then.
So, trial work is extremely hard. And, one of the things is you have to find that balance. So when my daughter was 8 months old, and this was many years ago, she's a bit older now, I was out of town at trial and my wife and I were talking. She's like, do you want to grab ice cream? And I'm like, I can't really make a 3-hour trip back home. And she was like, let's meet halfway. So we found probably one of the worst ice cream stores along 301. And while the ice cream wasn't great, it was just what I needed mid-trial to see my wife and my daughter. She was at that point where she was finally starting to get to eat some, I guess real food, if you consider ice cream real food. Just seeing her light up, it made all the difference in the world. And the choice we have as attorneys is, where are we going to put our focus? And some people say, well, in the middle of a trial, you probably should not be doing, traveling, getting ice cream and all that. But, I disagree. I think really it allows us to take a step back and reflect and share what we're going through with the people who are ultimately probably most important in our lives, which is our family.
That means a lot. And I actually, not only do I agree with you, I actually think it's an amplifier to the work that we do. in the sense of, I mean, we represent people, right? Whether on our side, like we're representing those who've been injured, and on your side, you're representing people who have been sued, right? And if we're not able to relate with the people that we represent, and I mean, how can we go and advocate for them? And so if we're not going to actually take the time to live a full life and to be intentional about being with family and friends and maintaining those relationships, then I actually think it impacts our ability to do a good job. But let's dig in a little bit more about kind of what type of case that was, what that trial was about.
So really all I remember from that trial is a couple of things: getting ice cream, and it was in Gainesville, and it was a car accident. And, I was representing a person who, she was a young mother as well. And for me and you, we live to be in the courtroom. That's where we want to be. But, going back to what you said, we represent people and humans. And, while you represent the ones who are injured, I represent the ones who went out there and caused the accident. While they didn't mean to go out and hurt somebody that day, they still did. So it's hard to take the human aspect out of what we do, and just being able to go back the next day and say, on a human level to her, how are you? Oh, I got to go have ice cream with my daughter, and, still be there for her, walking her through the trial. It does create that connection with your client, whether it's, whatever side you're on, there's always a person who's going to be involved.
That's right. And it shows that you're a human being, right? And that you're not just the person showing up in a suit. What was it that came across you that was like, you know what? I got to do this. I know this isn't traditional, but I've got to take the time and make that trip and get that ice cream.
Just the fact, it was really the first time I was away from my daughter for an extended period of time. It was our first child, and my wife was like, let's do it. And I was like, you know what? Why not? This is the opportunity to kind of set the tone for the rest of, my career, my life. Now we have 3 kids, and I try to do the same thing with them on a slightly different level, meaning, if I'm in trial in town, I'll try to at least grab a dinner with them and then back to the office to work or something, so I'm not completely disconnected from them for an entire week. Even the focus of when I'm out of town, you can always find time. Okay. What we do is very time consuming, but if you can't find 20 minutes to, have that FaceTime call before they go to bed, you really need to, because that's, I talked about that case at 8 months old, when my daughter was 8 months old. I don't remember many of the facts, but I do remember the ice cream with my daughter. And that's what kids are going to remember, is the quality time that you give to them when you're doing your job.
What are some of the things that you have, put into action to hold yourself accountable? And I can tell you that one of the things that I do, and I'm sure you're familiar with it, is I post every weekend that I go and I take my 2 young boys to the James River here in Richmond. And the public sharing of that has a few purposes, right? But the one that's been most true to me is it's held me accountable. People will ask, hey, what's going on, right? And so for me, I have found that I need it on the calendar. I need that routine, because otherwise I know myself. I know I'll find the excuse. I'll just continue to work, right? And I can come up with 100 reasons to justify, just like someone can come up with 100 reasons to settle any given case, right? You can always justify something. What are some of the things that you've done, Jason, to make sure that you don't lose sight of what's really important?
So what I do is I have, from very early on, I've set time aside on a almost daily basis to focus on my family. So I tell people at work, look, generally around 4:30, that's when I stop working. Okay. I will then, do activities with the kids. We'll have dinner, and then they're in bed usually by 7:00. My daughter's now at the age where we'll say goodnight. She'll stay up, read longer, but I give myself that 2.5 hour window in the evening to get good quality family time in. And then if I need to, I can always go later on and get back on the computer around 7 o'clock and continue my work. I can also wake up early. So it's about making, personal sacrifices for the family. And then, so I may not get to watch a TV show or read a book or something, but at the same time, I'm taking 2.5 hours and investing that in my children. And that's how I do it. I don't have, a weekly routine at the James River. We take that time and we do what they want. Yesterday they wanted to go fishing, so we went fishing in our backyard. We're fortunate to live in Florida where there's lots of fish, alligators, and other fun things back there. So yeah,
yes, that scares the hell out of me, by the way. Like snakes, alligators, crocodiles, I don't know the difference, and maybe I should. But yeah, the wildlife in Florida is insane. Absolutely
it is
insane.
Awesome.
Tell me more about that.
So we're very lucky. We live on a canal that's connected to the St. John's. So we get all the freshwater animals that come in. So our backyard, we've seen otters, we've seen manatees, we see alligators on an almost weekly basis. And, I'm not from Florida. I'm not used to the alligators either. My neighbors, they're like original Florida people. So their kids are be back swimming in the canal, and I'm like, aren't you worried about alligators? And they're like, nah. I'm like, oh, okay. The kids are like, can we go in? I'm like, absolutely not. But, like, no, you're not jumping into somewhere I just saw an alligator. It's in their response is, well, the kids are big enough, an alligator won't get after them. I'm like, but the lady with her little puppy, they'll go after, and they're like, yeah, the little dog attract. So I don't get it, but, it's great that we live in an area. And I, even sometimes I joke with you, I'm like, what is that you guys are wearing at the river? Cause your kids are probably in like parkas and hats and everything. And we don't do that down here. We just go out, fish, and have fun.
Yeah. Like, do you know what a sweater is? No, I'm joking. But, so what's it, I mean, it's very clear to me and I know others who follow you, certainly, that family is a priority. And what has that been like in the workplace? Have you had experiences as an attorney where you've had tension between what's been expected of you and your priority of making sure you have that time allocated for your family?
So there is a balance. It's a give and take, and it's just setting the boundaries. And sometimes we have to cave to our job. I've taken depositions on a Saturday. I'll take depositions in the evening. I don't make it a habit, but sometimes that's the only chance we have to depose a doctor or, some other expert. So, there are those times where you just have to do it. And there are other times where it's like, well, my client works during the day. They don't want to take time off of work to give a deposition. I get it a lot from my clients. I see it sometimes with plaintiffs as well, Hey, I don't want to take time away from my job to give a deposition. Can we do it at 5 o'clock? No, we can't do it at 5 o'clock because that's when I'm not working anymore. That's my family time. This is, your case. You need to take the time, well, I don't want to take time. Well, I'm sorry, you caused an accident or you were involved in this accident. You need to take the time during your work day, get the deposition out of the way and move on. So, there is a give and take, and a lot of times you have to decide where you're going to push back and where you're just going to acquiesce and work a little bit more than you should on the evenings or weekends.
Culturally, have you experienced any pushback from the bar? Not the bar, but just the bar in general, or the culture of law, I'd like to think, has changed for the better or is changing for the better. When people talk about lawyers, they go to the Paper Chase movie, right? In law school, and how it's hell, right? And they talk about the big law hours and being available at any given time of day, night, weekend, whatever, right? Have you seen any of that or experienced any of that? And have you if you think it's getting better, getting worse, staying the same? Be interested in your thoughts on that.
So yeah, I know exactly what you're talking about. I have seen and heard about it. And, at one point I was told, I have to be willing to make sacrifices for my career, be it my job or, my family. And that family was simply a sacrifice I was not willing to make for my job, and that wasn't at my current firm or last firm or anything like that. But, I'm very open about what I do with my kids, what I do with my family. And I tell people that, and most of the time people have been extremely receptive to that. And I still continue to do what I have to do, even like when I'm on vacation. So it's not like the job ever stops. It's just how you prioritize and allocate your time.
What are your thoughts for like young lawyers, new lawyers coming into practice? Are they coming into a more receptive environment now than maybe 10, 15, 20 years ago? Have things changed?
I think so. And I think that has a lot to do with the culture. Down here, we talk about the pre-COVID lawyers and the post-COVID lawyers. I got my start pre-COVID when we would actually go to the courthouse, meet people, talk to people. You'd settle cases in the hallway. And now a lot of things we do are by Zoom. So it's easy to forget about how things were because it's been, a while that we've been acquiescing to Zoom. So will a new lawyer be able to do the same exact thing you and I are able to do? I don't know, but I hope so. It takes a while to get to the point where, and I'm sure, Sharif, you could probably just almost walk in and start taking a defense expert doctor's deposition and not need a whole day to work up to it like a newer associate might. But
that's right. There is something about like when you're early in your career and you have the flexibility, you don't have the family, you have to learn the job, right? You have to take the time to develop the skill set, especially because, law school is so divorced from the practice of law. And I enjoyed where I went to school. It was a good law school. I still think very highly of it, but I didn't know how to be a lawyer when I left. And so in order, especially the work that we do, the trial work, you have to spend the time, and that's not just 9 to 5, but at an early age or an early part of your career where you are grinding. Like, I don't actually think there's any kind of substitute to that, right? Like, I think you have to put in a significant amount of time to start developing just even a simple comfort with the law and with procedure and with preparing and going to court, right? Like, and I guess the luxury is that hopefully if you're younger, you don't have the same responsibilities as maybe somebody who's mid-career and has a family. But yeah, I can tell you that for me, it's every day, it is a struggle. It's a good struggle, but it's a struggle. I'm very grateful that I love what I do, that I work with an awesome team at a firm that I think incredibly high of, and everybody who works here. And I love the clients, I love the work, all that. But at the same time, like, I've also got home, and I've got my roles and responsibilities there. I've got my 2 young kids who are growing like crazy. I've got my wife who I have to be intentional about spending time in both of those worlds, right? And it's a constant battle. One that frankly I didn't have 5 years, right?
Exactly. Yeah. And you're right. Law school does not teach you to be a lawyer. It doesn't teach you the practice of law. And it's, even now, I never stop learning. At this point in my career, I'm still trying to sit in on depositions of experts that I haven't deposed yet. So there is that struggle of, can I keep going? Can I keep this pace up? And as a younger lawyer, that's where you really need to put in the time, is learning, shadowing, finding a great mentor who can help you, get to the point where you're able to later in your career say, hey, look, I'm done at 4:30. I'll be back on in 2.5 hours if I need to be. But other than that, I'm done for the day. It is a real struggle to get to the point where you and I are and able to really allocate that time. I went to law school a little bit after college, 9-10 years later. So even in law school, I had a slightly different mentality than some of my peers. I treated law school like a job. I started at 8. I was done by 4:30. I'm not a night person. Ask anyone anyone that I know. I like to go to bed early. That's, so me starting to study at 4:00 in the afternoon for a law school exam, I'm already done for the day. Even with trial work, 10, 11 o'clock at night, it's time to shut it down, because if I don't wake up feeling good, it's not going to be a productive day.
There's diminishing returns. I had a conversation with one of my colleagues yesterday, and it was funny. We were talking about a deposition that we had in our office, and it was a trial deposition for a trial that we have next week. And it came up, and I forgot the context of it, but it came up at one point. We were like, sometimes you can be too prepared, right? Like, and I know that sounds weird, like an oxymoron, like too prepared. What does that mean? But like, if we like grind so hard and get so much into the weeds, sometimes we lose the forest for the trees. And so in our cases, right, they're decided by regular human beings, by people who come and serve as jurors. And like the vast majority of our cases, frankly, aren't that complicated. Was there somebody at fault? And if there was, like, what was the impact on that person's health, quality of life? I sometimes wonder if like we are up at 11, 12 at night because we really need to be, or because we think that's what we feel like we need to do because that's what everyone else does. Really not for the benefit of the actual work, but for hey, at least I was up till midnight preparing for this case. So I worked hard regardless of the outcome. Like I worked hard, right? Even though I would argue, and I think you'd agree with me, that being up until 1 a.m. in the morning, it does probably more harm than had you actually like got a nice dinner and gone to sleep 9, 10 and woken up refreshed and ready for that.
Yeah, I completely agree with you. It is so, there's nothing worse than being underprepared to try a case. There's nothing worse being so overprepared that you're not a functioning person the next day. I've talked to trial lawyers who are like, I simply haven't slept the night before my closing. I'm like, how can you actually get up? And usually our closings tend to be on the defense side, like later in the mornings on the final day or in the afternoon. I'm like, how can you not sleep and still function and think? Because, what we really do is not only do we argue, but we think a lot. At least I do at trial. And one of the greatest things that I've seen, and I picked this up, and you'll know who he is on LinkedIn, it might be Chris Finley.
Finning, yeah.
Yeah. WGON. What's going on now?
That's how so this is the trial binder that we have for next week. And I stole this from him, and I think he stole it from Joe Freed, and Joe Freed and Chris Finney are both just awesome people and freaking incredible trial lawyers. But you're right. Like, if you don't have the capacity or the bandwidth to be present and to actually to maneuver and if you're to the point where like you don't know your case well enough and you're up till midnight cramming like that, there's some real problems there, right?
Yeah, I've even seen that with other attorneys. Like I'll come in and I'll try a case with another attorney, and the entire time a witness is talking, they're sitting there taking notes. And I'm like, well, what are all these notes for? You have like stacks of notebooks of witness testimony. Yeah. What are you going to do with all this? And it's like, oh, well, that way if somebody asks me what they said, I'm like, well, there's a transcript. And if you're not actively listening, but more concerned about writing down everything they say, you're not going to hear what they say. Like those important little words we can then take and use in, your closing, my closing, cross-examination. It really puts the focus on what's going on right then and there. So
The notes are a crutch, man. They really, really are. And and I'm guilty of, right? Like for many years, I would take notes for everything. Like I'm guilty of it. And I forgot what it was. It might've been I think there's a book. Actually, I think there's a book. It was by F. Lee Bailey, who everyone knows F. Lee Bailey is. He was on the OJ case, super famous criminal defense lawyer. I think it ultimately had some troubles and lost his license, but considered one of the greats. And he wrote this book called To Be a Trial Lawyer, and I read it a long time ago. And I remember him talking about this note thing. And it's like, stop taking notes. And I'm like, that seems completely counterintuitive to everything you see and learn as a lawyer, right? All this, be prepared. And then I saw that theme replayed and advocated for over and over again through the Jerry Spence stuff, through the Trial Lawyers University stuff. It's like, just be present. Like, just listen. You know your case at this point. And the notes, I genuinely believe, Jason, they're a crutch. Especially like or you're not prepared, right? I mean, like, have you ever seen, and I'm guilty of doing this, right? But the legal pad, and there's a direct examination. The lawyer who is preparing for their cross to go next has this legal pad, has a line down the middle. And then on the left side of the line, right, they're writing stuff. And I've done this, right? They're writing what's going on in the direct. And then on the right side of the line, they're writing like what their response would be, right? Well, and then when the direct is done and they get up for cross, they get up and they go, and I'm saying this in full, like, I've done this. Like I've learned this the hard way, like I do. And my wife will probably say I learned most things the hard way, and she's right. but then they get up and go, well, you testified this way on direct, but really you meant this. And I call it the, are you sure cross? It's not effective, right? Like, yeah, I'm sure you agree with me that if you don't know what you're going to do on cross before the trial even starts, then you're behind.
Yeah, I have all my crosses done before a trial, and maybe while they're giving their direct, I might write one or two things down that just catch my ear, and that's it. I'm not sitting there scribbling notes the entire time working on my cross. I know my points. I know what I want to get out. What the expert, doctor, whoever witness is going to say is not a surprise. I know what they're going to say already. That's the whole point of a civil trial, not going in there blind. So I find taking notes the entire time, you're missing the big picture.
So we have a lot of young lawyers who listen to this podcast, and super grateful for them. But one of the things that I've always kind of preached is like, if you want to do this type of work, you have to find a way to get the reps. You have to get the experience. In a perfect world, like you alluded to earlier, you got to find a good mentor and a good place to work where you can learn. Trials especially on the civil side. I mean, I think I've had 2 trials this year. I've got a third next week. But I mean, if we get 3 or 4 trials a year on the civil side, on the plaintiff civil side, that's a good year. And yes. I tell people, like, go do criminal work, because it just doesn't really, I mean, to get that first year experience on the civil side is very hard to come by. But I don't think it was that way 10, 15, 20 years ago. So for people who are in your line of work and who are the newer lawyers, what are you telling them to do when it comes to developing their skill set and their toolkit as a trial lawyer?
So the best thing you can do is attend events. Like, you may not be the one taking a deposition, but the partner, the client, they're never going to let you take the deposition if you've never seen one. You know, I tell all my associates, and even, myself, I'll shadow other partners in the office who are taking depositions just to see how they do it, just so I can hear it. It's like you said, it's like going to the gym. It's getting as many reps in as you can before game day. Sitting on that, biomechanical expert, sitting on that engineering expert. On my side, at least, the associate can't bill for it. Okay? The client's not going to pay for 2 people to attend a deposition. But that's part of the experience of learning your job, learning your trade. You might have to eat 2 hours of your time to sit in a deposition, but you got to do it in order to hear what's going on so you can talk knowledgeably about it. The same goes for, we're in a very intense field in terms of the medical. You you need to learn that like it's the back of your hand. If you're talking to on my side, if you're talking to an adjuster and they start talking about, all the osteo fights they see, and you just don't know what they're talking about, you're already at a very huge disadvantage, because that's, 90% of what we deal with has to do with spinal injuries. So you got to know your craft, you got to get the reps in, and you have to show your partner, the client, that you're ready to go in and do the job. So it's hard work at first, and then does it get easier? No, but you're allowed to put parameters on what you do.
One of the things I really love about at least the plaintiff's bar for civil personal injury work is the collegiality and the training events. And there's tons of them. I've been very fortunate enough to attend a lot of them and learn so much. What is that like on the defense side? Is there that collegial kind of, or that camaraderie among defense lawyers? Would you mind kind of pulling the curtain back a little bit on that for us?
Sure, I'll do the best I can in, Florida. I don't know about everywhere else, but, that's one of the things I always say. The plaintiff's bar, we in theory have the same amount of cases, right? Because you have a plaintiff, you have to have a defendant somewhere. The plaintiff's bar, from what I've seen, they do a lot better of a job of sharing information. It's not like, hey, this is my client, I'm going to keep this motion or this practice a secret. I don't want anyone else to find it out. On the defense side, it almost seems like, hey, I came up with this great novel argument, but it's mine. I'm not going to share it with you. Well, secret's out. Once you file it in a motion, it's public record, at least in Florida. Everyone's going to find it. So it's not as open and sharing as the plaintiff's bar appears to be, because,
why is that? Like, what is it about? I mean, is it competition? Is it contracts with these insurance companies? Like,
I don't know.
Plaintiff side's competitive too, right? I mean, now granted, there's a spectrum, right? I think I have found that those who are more interested in the true trial work tend to be more giving and sharing versus the more commercialized, like just kind of churning through cases. So we certainly aren't perfect on our side, but there is a ton of sharing. What is it about the defense side that you think make limits?
I truly don't know. I think it's a concern over, clients, hey, if I have this great idea and I'm the only one who has it, all the clients, all the carriers are going to send more cases my way. I don't know. I think everyone should share, because if we find something great, it's for the greater good of the industry. The firm I work for wrote a book on basically, it's the how to try cases from the defense side. So they're out there putting the information out. It's just, I don't think it's shared in the same manner, possibly.
And if I'm correct, like not only has your firm written the book, right? It's about nuclear verdicts, but you guys also like do trainings, right? There's a defending nuclear verdicts, right? I'm sure I'm butchering that, but I'd love to learn more about what that is. And I know that's probably a sensitive spot, because the plaintiff's lawyer is going to be like, what do you mean a nuclear verdict? You mean a just verdict, a fair verdict, right? And then the defense lawyer in you is probably like, these verdicts are out of control, But like, so let's get into that a little bit.
Yeah, that's an interesting point. The book is available on Amazon, but if you're lucky, maybe one will show up on your doorstep for the holiday season.
As long as it has pictures, I'm good. Remember, we went to VMI, Jason.
Yes.
Too many words is a problem. Anyways.
Too many words, not enough pictures.
That's right. Actually, can I tell you a quick story? This is embarrassing, but I remember at VMI, one of the ROTC classes I took, because VMI, it's a military school, everyone has to take ROTC. And I mean, ROTC, like, they don't care. Like, I mean, not that they don't care, but like, the interest is like, service is developing skill sets to serve, all that stuff, right? Like writing papers, like, yeah, okay. And I remember we had to do this book report thing. I put in a bunch of pictures, and my buddies were like upset with me. They're like, what are you doing, Sharif? Like, you basically like half your paper is pictures, like to try and hit the page limit or whatever. And I was like, yeah, man, like I like the pictures, and like, it's not going to matter, right? And that would be me being kind of whatever. I wasn't being the greatest student. everyone got an A on the paper. It was remember, it was an RTC class night. And then I got the comment, great visual depictions. And I was like, yes. But anyways, I don't know. I felt the need to say that, but yeah. But
That must have been the Army, right?
it was Army. It was Army. It actually was Army. Yeah, I'm sure if it was Air Force, they would never have let that fly. But in Marines, they probably would have made you roll around in mud or something like that, which is another story actually as to why. I mean, I'm still to this day jealous and envious of the Marine Corps uniforms and all that stuff. And I remember wanting to be a Marine, but I also remember this gunnery sergeant at VMI, and we were on this hike, this ruck. Well, we don't hike, right, at VMI. It's the ruck. And there was this puddle, and this gunnery sergeant, I mean, just an absolute badass, by the way, just like crawls through it and like gets up and does whatever they do, says whatever the Marines say, the grunts or whatever. And then like all these like first classmen, which are seniors, do the same thing. I'm like, this isn't for me. Like, I can't do that. So I went and signed up for the Army. So that says a lot about me, I'm guessing.
Thanks. Like, yeah. well, that reminds, when we had a breakout, we climbed up the hill, the muddy hill. And afterwards I was like, can we get this please off of me? Like, I'm not a huge fan of being like, in the mud and all that. They loved it. The Marines loved it. I was there with a bunch of great from our ROTC staff. There were some really good ones that were there. But
the things that we do in ignorance, right? Like not knowing what it's like at JMU an hour up the road. Right? Like, well, let's get back into this nuclear verdict thing. So what is a nuclear verdict? Why is that phrase used?
So basically a nuclear verdict is any large or anomaly verdict that's not supported by the facts. Just because a verdict is high does not mean it's nuclear. I mean, if you have a 17-year-old kid that is, valedictorian and they get a couple $1 million verdict in a wrongful death case, is that a nuclear verdict? Well, as long as it's supported by the facts, most likely not. If you have somebody who goes to the chiropractor one time for a car accident and is otherwise fine, and the verdict is, $28 billion, is that a nuclear verdict? Probably yes. Because
I'll take that one though. I'd be happy to have that one. I'll split it with you. But no, I agree with you, right? I mean, I think the argument is it's the eye of the beholder as to whether or not it's supported by the facts to some degree. But I think most people should agree that like if somebody is hurt and all they have to do is go to a chiropractor for a visit, they should not be recovering some multi-million-dollar judgment, right?
Right. Yeah. And, the book really does a good job of really defining what is nuclear. A lot of times we see large verdicts that are supported by the evidence the jury hears, or a lot of times you'll see, a large verdict that should have been larger, So it's not just a large verdict that is that's a nuclear verdict. It's like, what are the facts around it? Just because you have a low verdict, that, same thing. That doesn't mean that's a just verdict either. It's, what are the facts? What is the real outcome of the case? And is it supported by the evidence?
It's a really good point. A good friend of mine was telling me about a case he defended a few years ago. And I remember him explaining like, the offer in the case was in the 7 figures. And like the verdict was just, the offer was, I forgot the actual number, but let's just hypothetically, let's say the offer was $8 million and the verdict was like $9 million, right? So like, is that actually a huge win, right? Like, not really, right? It sounds like the case probably deserved that. The injuries, the conduct warranted, or the evidence warranted a verdict like that, right? I guess the nuclear is the term that I imagine is probably used more often when there's that mismatch, right?
And I think that's exactly what it is. It's that mismatch. Because, if the offer was 8, you got 9, it seems like you're not that far off in, the evaluation of the case from either side. I've been in a similar situation where, we've offered a substantial sum of money, go to trial, and it's less than I asked for at trial, and I can't even figure out where the jury came up with this number. So jury trials, while they're great, that's what we do. you never know. And it's a very unpredictable outcome for everyone.
When it comes to valuation, from your side, what does that look like?
So I've been doing this now close to 20 years. Prior to an attorney, I was an adjuster for an insurance carrier. So, then I went to law school and now I'm doing defense work. So I take a look at, the facts of the case, liability, damages, the medical treatment, the plaintiff lost wages, and what is the value of the case in the area in which we're in. And I know that's kind of vague, but like valuation's very hard. It's not really the same any two places, for what I value a case is going to be extremely different than what you value a case just based on your, location. And a case in Jacksonville is going to have a different value than a case in, Clay County, which is almost next door to us.
Does conduct ever come into play with valuation? And all kind of in candor, I believe it does, right? Like for example, we have a case that has resolved for limits and there was no medical treatment, but it involved a young man, a vulnerable young man with significant disabilities who was burned by an iron at a center he was supposed to be taking care of that, right? And that's not your traditional personal injury case, of course, right? I mean, your traditional personal injury case is where there's some sort of car collision and there's some sort of orthopedic, chiropractic, whatever, right? But in those cases, how does the defense side value them? Because I remember in negotiating that case, the first questions I got from the adjuster, and I recognize it's just one story. This is just an anecdote, right? It doesn't paint the picture for the practice or the industry. But it was like, well, why do you think your case is worth the policy limits? I mean, there aren't really any medical bills or any medical records. It was like, well, I mean, can iron to guys. Like, I mean, kind of, right? I mean, this is not good, man. And I mean, it's once we sent a large demand and like explained our case, right? Ultimately it resolved fairly quickly shortly thereafter. But in cases where conduct is concerning, where there's like a punitive element in some sense, how do you guys go about valuing those?
So punitive damages are always something that we're looking at if they're in play. Not everything will rise to, if somebody goes out and just has no case is ever simple, because nobody sets out that morning to have a car accident, collision or crash, whatever verbiage you'd like to use. I say accident, because nobody gets up in the morning and says, hey, I'm going to rear end another car. It happens. If it's just a pure unintentional act, that's different than, the person who was at the bar for 6 hours, had 17 vodka tonics and then gets behind the wheel and, runs into a school bus. Completely different. So, we do look at conduct that way. Other ways it can be looked at is, in premise cases, if there's actual or constructive knowledge of a defect or, substance on the floor, things like that. So it does get factored in. It's just, to what level. And sometimes it's, our job as defense attorneys to let the adjusters know that, hey, this is a very important fact that I understand it may not fit nicely into the evaluation, but it's something we need to consider because if it comes out in trial or later on, a jury's going to be very upset by it.
Do you guys focus group cases on the defense side?
Yes.
What does that look like?
It's interesting because you actually get like the mock jury. You're going to see and hear what a potential jury is going to do and talk about. You're going to get their honest reactions to the arguments that you made, how they perceive the evidence and what gaps they see. I mean, I think it's a great tool for the right case. Now, some auto cases, we won't focus group just because of this set of facts, but other ones, we'll sometimes do 2-3 focus groups on them just to see, should we argue something this way? Should we argue it that way? And it really gives us insight into how a panel's going to view our arguments.
Does the plaintiff trial lawyer's reputation or record for litigating and going to trial? Does that make a difference in valuation from the defense side?
I can't speak for everyone. I work with so many different clients and, carriers, and I work with all these attorneys. A lot of times we'll be dealing with people who are out in, another state, and they're like, well, just do X, Y, and Z. And you're like, I understand, but I have a professional relationship with, for example, if it was me and you, like I have a professional relationship with Sharif. I can't do X, Y, and Z because once this case settles, I'm going to have 6, 7, 8 more cases this year alone with him. And it does matter to a certain extent, the competency of the firm, the ability to try cases. Never want to disparage another attorney, but we know which firms, which attorneys, which will go ahead and try a case. And, anymore it's becoming, any firm down here can really go up and try a case.
I've always wondered how closely the defense or the insurance industry tracks that. I mean, my thought is they have to, right? They have to. Because I remember, especially doing criminal work, I knew if the case was going to plea just based on the attorney on the other side. I knew, right? And of course, there's exceptions to every rule, right? But I found that reputation and track record really did matter.
And I think it matters if the carrier or the adjuster knows who you are. I once had a very bad accident with a commercial vehicle, and the adjuster was in another state. I was telling the adjuster, look, you need to resolve this because the firm who had it, this was their bread and butter case in Duval County. You're looking at a 7-8 figure verdict if you go to this. And they're like, well, we've never heard of them before. And it's like, well, I suggest you Google them, please. And, look, insurance adjusters are great people. I work with a lot of great ones, and they have a very hard job. A lot of them have hundreds of cases that they're trying to resolve. They handle large areas. And while I say that, I don't know every attorney in Miami. I don't know every firm in Miami. So that's really where you rely on your local counsel or somebody in the area who can provide you that guidance. Like, hey, you might want to watch out for, this firm in Miami. And they're going to ring your bell if you go to trial. That's the type of firm they are. So, of course, nothing against the insurance adjusters or anything like that, but it's just,
it sounds like what I'm hearing, it's a factor. I mean, you would probably not be doing your job if you didn't recognize that that's a factor that goes into consideration when it comes to valuing settlement positions, right?
Right.
Yeah,
exactly.
Yeah, it makes sense. Well, Jake, this has been a ton of fun. I've got another question for you. Do you have a few more minutes?
Yeah, go ahead.
If you could go back in time to when you got that law degree and give yourself some advice, what would you tell yourself?
I would go back even further in time. Grades matter. No matter what anyone tells you, no matter what your plan in life is, undergraduate grades matter. When I was at VMI, I didn't have the best grades. I majored in the Palms and Spankies when that was still around. Years later, I was very fortunate in law school. I was able to buckle down, study really hard. But for those in law school who are looking to really do it, get involved in the clinic. Get involved if you can intern with state attorney, the DA's office, the PD's office. Get actual trial work experience where it provides something to you, a usable skill. Because if you want to be a trial lawyer, the first step is getting in the courtroom, seeing what's going on, and getting reps.
Jason, this has been a lot of fun, man. I really hope we get a chance to meet up at VMI here soon. So I'll actually be there on Saturday doing the honor court training thing that I'm so lucky I get to go back every year to do. But thank you so much for being on the podcast. It's really been a privilege. Thank you, Jason.
My pleasure. Thank you.
Thanks for listening to Courtroom Stories and Tactics by RVA Trial Lawyers. Hosted by Sharif Gray and Niall Abuzaki. Please subscribe and leave us a review on Apple Podcasts, Spotify, YouTube, or any major podcast platform. Together, we're building a tribe of trial lawyers to remind the world what human life is truly worth, one verdict at a time.